Hello and welcome to the Law Lab. Here, we dissect and unpack everything legal. Once again, my name is Jacqueline Fua Opoku, and today I'll be continuing with misrepresentation, but we'll be focusing more on the types of misrepresentation. In our previous video, I introduced us to what misrepresentation is, and I said that it is a false statement which is made by one party to the other party with the intention of inducing that party into the contract, and that party also relies or is able to be induced by that false statement to enter into the contract. Today, our attention will be on the types of misrepresentation. As I have already stated, our focus will be on the types of misrepresentation. But before that, I want us to know that the main effect or the effect of misrepresentation is that once misrepresentation has been able to be established by the courts that the contract which has been entered into by the parties was born out of misrepresentation of fact, then it is voidable at the option of the party that was misled by these false statements that were made to him or her. I will state it again. The effect of misrepresentation is that it makes the contract voidable at the option of the misled party. That means the misled party has the right to either rescind the contract or claim for damages. With the types of misrepresentation, there are three main types of misrepresentation. And the first type of misrep or misrepresentation is known as the fraudulent misrepresentation. When you hear fraudulent, it simply means anything that involves fraud. And what is fraud? Fraud is usually based on deceit. You are deceiving the other party on the terms or the statements you are making. That means you really know that whatever you are saying is not true, or even if you don't know that it's not true, you are very much aware that you are making it recklessly. You do not care about the effect that is going to have on the other party. Fraudulent misrepresentation means that making a false statement to the other party without belief in the truth of it, or making a false representation of fact to the other party and knowing that though the existence of that fact cannot be proven, or you yourself, you do not believe in the fact that you are stating to the other party. When that occurs, the court will hold that the contract was born out of a fraudulent misrepresentation of fact to the other party. In the case of Derry versus Peak, the court gave us a guideline to know whether or not a contract amounts to a fraudulent misrepresentation. The first thing they stated was that the statement made is known to be false. This ran through all the types of misrepresentation because misrepresentation in itself amounts to a false statement. Therefore, fraudulent misrepresentation, the party or the fraudster who is making that misrepresentation knows very well that the statement of fact he is making is actually false. And the second is that they make this statement without belief in the truth of the statement they are making. And the third thing is fraud is an essential element of fraudulent misrepresentation. I have already stated that when you hear fraudulent misrepresentation, that means there is an element of fraud. Therefore, you cannot establish fraudulent misrepresentation without showing or proving to the court that there was the essential element of fraud existing in the fact that the person made to you. And when the person make this fact to you and you want to rely on fraudulent misrepresentation, you must be able to prove to the court that you relied on the fraud that they made to you or they represented to you to enter into the contract. The court in Derry versus Peak held that where a fraudulent misrepresentation has no element of fraud, it's likely that the cause of action will fail. What is the effect of fraudulent misrepresentation? The effect of fraudulent misrepresentation is that it makes the contract voidable at the option or at the instant of the misled party. That means the party who has been misled is entitled to either set the contract aside or claim for damages. But I will not use the word "or" because when you go to court seeking for the remedies, the court will allow you to rescind the contract. That means set aside the contract and will grant you damages for the losses that would flow from the losses that you incurred when you performed your part of the obligation. The second type of misrepresentation we'll be looking at is negligent misrepresentation. The word negligence simply means that you owe the person a duty of care. And duty of care will arise out of a contract between you and another party. Under the old law, it was believed that for negligent misrepresentation to occur, there has to be a contract that exists between the parties. Therefore, you cannot claim negligent misrepresentation where no contract existed between you and the other party that breached that duty of care. So in the famous case of Donahue versus Stevenson, the court came up with a principle called the neighbor principle. That means whatever you do for your neighbor, you should know that the neighbor is intended to do the same to you. In that case, the court made us realize that we do not only have to rely on a contract that exists between parties to hold the other party accountable for breaching the duty of care he or she owed to the other party. I'll state it again. In the old law, it was held that for negligent misrepresentation to amount, that means there had to be a contract that existed between the parties, and that contract amounted to a duty of care owed by the other party to the other party that was misled, and that duty of care was breached. This was held in the case of Candler versus Crane Christmas. In this case, the court stated that for one to rely or for one to rescind a contract by stating that there was negligent misrepresentation, that party who seeks to rescind the contract must be able to lead evidence or must be able to show the court that the other party owed him or her a duty of care and that other party breached this duty of care. Hence, the need for the court to allow that person to rescind the contract for negligent misrepresentation. But the new law, as held in the case of Hedley versus Heller Partners, the court realized that most people were taking advantage of the fact that there was no contract existing between them and that they had breached a duty of care. They realized that most often contracts do not exist between parties, but rather there is an existing duty of care that automatically arises because of the relationship that exists between the parties. Due to this, the court in Hedley versus Heller Partners decided that you no longer need a contract to exist between the parties for a duty of care to arise for there to be a breach of it. The court held in this case that so far as there is a special relationship that exists between the parties and that special relationship gives rise to a duty of care, so far as that duty of care is breached because of the special relationship owed by the parties to each other, then the other party who did not breach that duty of care will be made to rely on negligent misrepresentation and sue to rescind the contract and claim for damages. In short, negligent misrepresentation no longer needs a contract for a party to rely on it that there was a breach of duty of care. In the case of Esso Petroleum versus Madden, the court once again held that so far as there is a relationship that amounts to a duty of care, a relationship like a relationship between a lawyer and their client, a doctor and their patient, or bankers and their customers, so far as there is a kind of relationship that can allow a party to rely on the duty of care owed to him, and when there is that breach of duty of care, that party can come to court and sue to rescind the contract and claim for damages. The last type of misrepresentation we'll be looking at is innocent misrepresentation. When you hear the word innocent, it simply means that you are not guilty. Not guilty of what? You are not guilty of misrepresenting or making a false statement, but due to certain circumstances, the statement that you made thinking that they were true statements out of certain circumstances that you did not even think about, these circumstances make the statement that you made become a false statement. So in simple terms, the definition of innocent misrepresentation is that a false statement is made, but mind you, the person made that statement believing that it is true, or the person made a statement in good faith. In good faith means that they actually believed in what they were saying. They didn't make that statement out of recklessness or out of negligence. So, for you to define innocent misrepresentation, you must state that it is a statement that a person makes in good faith but turns out to be untrue. So that party cannot be held liable for making a false statement. Due to this, the court only allows the misled party to sue to rescind the contract, and you cannot sue for damages. So the only remedy available for you is that you sue to rescind the contract, meaning the fact that you relied on to enter into the contract has been proven to be false, which is of no fault of the other party that made this false statement or that made that statement. In the case of New Begin versus Adam, the court held that for innocent misrepresentation, the party who is being misled has the right to set aside the contract but has no remedy under damages. But then the court went ahead to say that he or she can be indemnified. Indemnity means that you will be compensated for the losses that you incurred when you performed your part of the contract. But damages arises out of breach of a contract. You get it? That's the difference between the indemnity and the damages. So far, we have discussed the three types of misrepresentation. I started off by telling you that the effects of misrepresentation is that it is voidable at the option of the other party, meaning the other party that was misled can go to court and sue to rescind the contract. We have looked at the three types, and I stated that they are fraudulent misrepresentation, and that in fraudulent misrepresentation, there has to be the essential element of fraud. So if you cannot prove fraud, the court is very reluctant to state that the contract was born out of fraudulent misrepresentation. And also, I spoke about negligent misrepresentation, of which the old law stated that there had to be a contract, which was held in the case of Candler versus Green Christmas. But the court in the case of Hedley versus Heller Partners came out with a new law that you do not only need a contract, but then any form of special relationship that amounts or that allows a party to owe a duty of care to the other party. And then when there is a breach of duty of care, the other party can rely on negligent misrepresentation and rescind the contract. Also, we looked at innocent misrepresentation by letting you know that innocent misrepresentation, the person made a statement believing in it, or they made the statement in good faith, but it turned out that the statement was untrue, and that untrue statement was not a fault of the other party, and you are only entitled to sue to rescind the contract and not allowed to sue for damages. But you can also sue for the court to indemnify you of all the losses that were flowing from the liabilities that you incurred while performing your obligation. In the next video, we will end our topic on misrepresentation by looking at the remedies of misrepresentation and the bar to misrepresentation. Thank you for joining me in today's discussion. I urge you to continue to like, comment, share, and subscribe. Let your friends know that we are discussing misrepresentation under contract law. Thank you.